Hello, everyone. Welcome to Court with Krissy. There isn't a small claims case that I won't sit through. And here are 4 recent favorites from Thurston County. I hope you like it. Court with Krissy is now in session.
Ms. Carper?
Yes, I'm here.
Okay. Do you have video capability there?
I can try.
Okay,
Can you see
there
me?
you go. Yes, I can. All right. First question, Ms. Blocker, are you in Texas?
I am. Where I've been
Okay.
since 2020.
All right. And Ms. Carper, what's your relationship to Ms. Blocker?
She is a former friend, former roommate.
Okay. So this lawsuit is over a loan, some property damage to some property the 2 of you lived at, and then some storage fees. Is that essentially it?
Correct.
Okay. So Ms. Blocker has appeared today. So I'm assuming you were served in Texas, Ms. Blocker, but what I'm going to tell you, and I feel compelled under the law to tell you, which is a reference back to what I said before about sometimes the law intervenes on people's view of the facts or what's right and what's wrong. There is no what's called long arm jurisdiction in small claims cases, which means we cannot force somebody from another state to appear in a small claim action. So Ms. Blocker, it's your choice. You can choose to go forward on this case today, or you can say, no, I'm not submitting to the court's jurisdiction because I'm out of state in Texas and you can't sue me in the state of Washington. Now, Ms. Carper does have the option, if that's what you choose, she can then sue you in Texas for this very same thing. But that's up to you.
I'm going to take that
The
option.
real estate property in question is in Washington.
Yeah, that's not good enough.
For our
No.
Okay.
All righty.
No.
Thank you, Judge.
Okay, so hold on. I'm going to dismiss the matter without prejudice, which means that it can be refiled. Ms. Carper, if you want to maintain this action against Ms. Blocker, you're going to have to do so by filing in the county where she resides in Texas. All right, thank you.
Thank you.
Hey, you can come on up with him.
Up here?
Right there at the table.
Oh.
Go ahead, I got it.
All right, and if you would raise your right hand, please. And Ms. Huerta, raise your right hand. Swear the testimony in this case will be the truth, the whole truth, and nothing but the truth.
I do.
Yes.
Okay, you may be seated.
Gotcha, Dad.
I have read the pleadings that were filed in this case, and I want to make sure that Mr. Steelberg can hear me.
Yes.
Okay, and is it Steelberg or Stylberg?
Style, yeah.
All right, I want to get it right. All right, so you'll let me know, Mr. Stylberg, if you can't hear me.
Okay, thank you.
All right. So I have read what has been filed in this case, and I understand that there was an injury to Ms. Huerta's dog, medical bills resulting, to Ms. Huerta, as well as to a dog on a previous occasion. And Ms. Huerta's medical bills were, I believe, $21,479 as a result of this. And Ms. Huerta, you indicated in your statements that you provided to the court that it was Mr. Stylberg's dog that caused this injury to you, and on a previous occasion had seriously injured your dog, which you did not pursue any action on, but it made you cognizant that the dog at issue is a dog that Mr. Stylberg had out at the Steamboat Island fields.
That's correct.
Okay, Ms. Huerta, do you have anything more you would like to add?
No, that's it, Judge. Thank you.
Okay, so I'm going to ask, just for the purpose of our record here, just make a very brief summary of how you came to have his contact with Mr. Stylberg's dog.
As I noted in my document, originally, ironically, had an encounter with Mr. Stylberg's dog about 3 years ago, walking at the Griffin Fields in Olympia, Washington, and Steamboat Island area. And we encountered, my partner and I encountered what I know now as Sadie, his Labrador, who who got away, or was, I don't know if the dog was originally leashed, but got away from Mr. Stylberg, and aggressively attacked our dog. And at that time, and we were actually very concerned with Mr. Stylberg, because he fell quite violently actually on the trail when the dog, during this dog attack. We had 2 dogs leashed, and so as a result, one of our dogs was seriously injured. And at that time, we were able to get our dogs back in the car, but mostly we were very concerned with Mr. Stylberg. We helped him up. We checked to see if he was okay. He got control of his dog. We got our dogs back in the car, and we immediately went to emergency vet. At that time, we were able to get some information. We had to go back and find Mr. Stylberg so that we could get some contact information. He reluctantly gave it to us, but we got it, and we called him back to find out could he help us with the vet bill at that time. He told us, he and his spouse, I believe, told us that they couldn't afford it. So, you know, we honored that they couldn't afford it. We took on that bill. Since then, we never returned to the Griffin Athletic Fields, thinking like, oh, we never want to have that happen again. So ironically, on March 5th of this year, we were like, hey, it's a beautiful day. I'm going to take those 2 dogs out and, and just do a quick lap. And ironically, just as we were leaving the park, I couldn't believe it, but there was Mr. Stylberg and the illustrious lab, sadly, Sadie, who got away from Mr. Stylberg and immediately just charged us right as we were getting to the parking lot. And I couldn't believe it. I immediately just jumped to pick up my small dog and hold back my other dog. And the dog, Sadie, just went for my leg and just chewed my leg up. So it's been 3 months of having these injuries attended to, deep bites. And as a result, I've incurred a lot of medical bills, and that's where we stand right now.
All right, so the 21,000 plus that you indicate were medical bills, they were all related to treatment of the injuries you suffered in that attack?
Yes, the most recent attack, yes. And they're still, I'm still waiting, I'm still collecting them. I actually just made an addendum to the statement I provided online. I just got a bill just recently, last week.
Okay,
So we're thinking, I don't know how many more bills are going to come.
okay, but you understand that in pursuing this action in small claims, which has a $10,000 jurisdictional limit, you are essentially foregoing the ability to recover anything above that amount.
Correct.
Okay, thank you. Mr. Stylberg, anything you'd like to say?
No. I'm sad that she went through that.
All right, thank you.
I love dogs.
I think we both share that, Mr. Stylberg.
As do I. And Ms. Huerta, the cost of you filing the claim, in this case, not the filing, but the service of the claim?
Is it for the service of the processing, or total? That was 150. It's in the
Okay,
doc.
you paid that to a process server?
Yes, yes.
Okay, thank
I
you.
think it's in the doc, it's in the evidence document. The receipt.
All right, in this case, Sadie, Mr. Stylberg's dog did cause injury unprovoked to Ms. Huerta. And as a result of that injury, Ms. Huerta suffered significant medical costs, well in excess of the jurisdictional limit of $10,000 for a small claims court. No defense having been presented, I will find judgment for Ms. Huerta in the amount of $10,000 plus the filing fee and service fee for a total judgment of $10,200. And we will provide Mr. Stylberg a copy of this, and we will also send a copy to you, Ms. Huerta.
Thank you.
You're welcome. All right. Thank you. Yes. Thank you, Mr. Stylberg.
Thank you for these hearing aids.
Okay.
Oh, your necklace too. This.
Thanks.
Sorry. Thank you guys. Have a good day.
Yeah, bye-bye. And Ms. Jordan?
Good morning, Your Honor.
Good morning. Did Ms. Buxton get served?
Yes, Your Honor. Once via mail and also by my neighbor on the same day.
Okay, let me check here.
I believe it was the 17th of last month.
Okay, so the certificate of service that I have is something that says there was service by mail, but it was supposed to be a return receipt requested, and I don't have a return receipt signed by Ms. Buxton. So that certificate is inadequate to tell me that she actually received the mail. And that's the only one I have. I don't have anything that says she was handed a copy of the notice.
Are you talking about the green slip that the
Yes.
post office?
Uh-huh. Yes.
Yes, I have that. I don't remember if
Was it signed by Ms. Buxton that she picked it up? The post office has somebody sign that when they pick up the mail, and then they send it back to you so you know that they picked up the mail.
Right. The instructions that they gave me was, that the post office gave me was to type in the numbers on that receipt, to view signature online.
Right. And okay, so you should take a screenshot of it if you are able to see it online, because I don't have it here. I have nothing here to indicate that Ms. Buxton actually has been served. I see that somebody signed something and I can't make out their handwriting. It looks like they said that they put something in the mail to her, and actually, nobody actually signed this certificate of service. So this certificate of service wouldn't even be effective for telling me that somebody put it in the mail, because somebody filled some information out but never signed it. So the document that I have
That one
doesn't
was,
qualify in any way for service, just so you know.
that one was probably the neighbor. I possibly didn't submit the one that I did, what is it called? The one with the slip.
Okay, the certified mail. Okay, so at this
Should,
point, we can't do anything today. And now, if you have the green slip and she signed for it, then take a screenshot and send that in to us, and then I can award a default judgment to you because she has not appeared. And if somebody, I think you told me you thought somebody actually handed her a notice, is that accurate? Or you just may have?
I'm sorry, go ahead.
Was it just mailed to her, or did somebody actually at some point hand her a notice?
Both were mailed. The neighbor went to her house. I did the slip.
Okay. All right, so I don't have anything from a neighbor saying it was handed to her. So I don't have any document regarding that. If there is a document and they sign it under oath that they actually handed it to her, then you can submit that to the court. Or if you have a screenshot of her having signed the return receipt, then you can send that in. If you do that, then I'll award default judgment. Otherwise, we are going to have to reschedule your case if that's what you want us to do, so you can get us actual service.
Okay, thank you, Your Honor. Should I do schedule hearing?
Well, yeah, so the way this, if you
Continue.
think you have the proof of service, then send that in, get it to the court, make sure we get it, and then you don't need another hearing. If you don't have actual proof of service that she either signed for the mail or was handed notice, then call the court and have them reschedule your small claim. And then you'll have to get service again.
I understand.
Okay? All right.
Okay.
Thank you, Ms. Jordan.
Thank you. Have a good day.
This one's straight ahead.
Okay. And if the Wesenbergs, there we go. If you all raise your right hands, please. Oh, you're muted. You need to unmute. Bottom left of the screen, it would say join audio. You can go ahead and have a seat. I'll have you swear in when you're seated. That's fine.
Thank you.
Hello, sir. Hello, Your
All right.
Honor.
All right, and Ms. Wesenberg, and are you Spencer?
Yes, sir.
Okay, if the two of you would raise your right hands for me, please.
Of course.
You swear that testimony in this case will be the truth, the whole truth, and nothing but the truth.
I do.
Yes, sir.
All right, thank you. And Ms. Haley is present in court, and she indicates that. And is Spencer, what's the relationship of Spencer?
Spencer is Linda Wiesensberg's youngest son.
Okay, and Linda, your relationship to her?
Been friends for 45 years.
Okay. So Ms. Haley indicates that back last fall, because actually, when did you initially loan the scooter to?
Probably 2 years ago.
Okay, 2 years ago, and then you needed it back last fall because your daughter had health needs.
Yeah, and they're getting worse now, so now it's becoming accelerated. She's diabetic, and so.
Okay, and to this date, you've not received return of the scooter. And you filed an action for $1,600. Tell me how you arrived at the $1,600.
What I paid for it used probably 3 years ago. I had nothing else to measure it by, so. I bought 2 scooters back then, and I paid $3,200 for the 2 of them. That was the better one of the 2, but I just split it in half, thinking that gives me the place to start.
Okay. And I'm going to guess, because I didn't see anything in here, that there wasn't a written loan agreement. It was, you just did it as a friend.
She had gone into the hospital, then into a nursing facility. When she got out of the nursing facility, because she's really an outdoorsy kind of person, I wanted her to at least be mobile enough to be able to walk around the neighborhood, get the mail, get outside.
Right.
And so I loaned her the scooter, just so that she would have some other means of mobility besides trying to walk, because she was kind of incapacitated at that time.
All right. And did you, what were the comments when you gave the scooter to her, relative to, is this a gift or is this a loan? Was there a discussion about that?
I was just loaning it to her for her to use until she got better. I would touch base from time to time and say, how's it going? And I really wouldn't ask for the scooter back.
Mm-hmm.
But she knew that it was on loan to her.
Okay. And why do you think she knew that?
Knew that it was on loan to her?
Yes.
Because I had told her directly that I'm loaning this to you, and
okay.
I'll want it back, but I don't need it back right now, because I had 2, and right. I said, but if I do, I'll just reach out and get it back. I know it's safe.
All right. Thank you. All right. Ms. is it Wesenberg or Wiesenberg?
Wiesenberg.
All right, Ms. Wiesenberg, go ahead.
Well,
say anything you want.
Say anything I want.
Anything you want.
What do you want to know?
Well, what I want to know is that Ms. Haley says she loaned you a scooter and you haven't given it back, and she would like it back and you haven't done that, and she's now seeking damages, which is the cost of the scooter, so she can buy another one.
Yes, that's
so you go ahead and tell me what's the issue with the scooter.
Apparently the issue is that my son loaned it to someone and didn't get it back.
Okay.
Without my knowledge. And apparently she tried to reach him many times, but had the wrong phone number or obsolete phone number, so he didn't know she was trying to reach him. I know this to Kay, it's a matter of principle. She's a lady of principle, and that dictates what she does. And that's why she's asking for damages. Okay. I think I don't remember it costing that much, but because I was with her when she purchased it. And, but she says I'm incorrect and could be. I don't know. I just think I was hoping she could just drop this suit against us because she's demonstrated her principles and what she thinks about the whole situation. She knows I can't afford to pay her anything. But if I have to, whatever you decide, oh, it would have to be hopefully something over time that I could somehow handle.
Let's don't worry about that.
And I'm sorry it affected our friendship, but if you get sued by somebody, it's gonna affect your friendship, and she knows that. I
All
know
right.
that. I know that. So I'm just hoping she can see her way to dropping the issue in hopes
All
that
right.
we can repair our friendship. Thank you.
Thank you, Ms. Weisenberg. And Mr. Weisenberg, anything you want to say?
I just want to express my appreciation to the court and the time that has been spent on this. Excuse me. It's got everybody pretty upset. There was never any contract, but I'm not trying to ask to be alleviated from any responsibility of it. It's just something that happened, and but there was never any contract of any sort, sir.
Okay.
Thank you. Thank you.
All righty.
You gotta plug it in.
Okay.
I want to make sure we're not going to be run over by a train. And Ms. Haley, what were your costs of serving the claim on Ms. Weisenberg?
$70.
Thank you. All right. In this case, I'll find that there was an agreement to loan a scooter. Ms. Haley was trying to assist her friend, Ms. Weisenberg, who had come out of surgery and lacked mobility at the time, and tried to give her an opportunity to be outside, and loaned a scooter to that effect. And that was a couple of years ago. And sometime over the last couple of years, Mr. Weisenberg loaned the scooter out to somebody else, and that scooter is now no longer available and gone, as best I can tell. And Ms. Haley has been asking for it back since last fall, when her daughter came in need of the scooter. and she's not received return of it during that period of time. She's now seeking judgment from the court in the amount of the scooter. And based on the failure to return the scooter, I will find judgment for Ms. Haley in the amount of $1,600 plus the costs totaling $120. So it'll be a total of $1,720, which she is entitled to for the inability to return the scooter. And I will note that the loan agreement was with Ms. Wiesenberg and Ms. Haley. Am I correct that Spencer was not part of the initial discussion about the loan? It was Ms. Wiesenberg.
It was for her. He lives with his mother.
Right.
I
mean, did you talk, was he part of the loan discussion?
He knew that I wanted it back and that I was loaning it to her,
Okay.
yes.
All right.
It was not party to
the use
the
of the scooter.
benefits of it.
Right.
Let's put
Okay.
it that way, other than allowing his mom to have.
Okay. So what I've done is I've removed Spencer as a defendant because I don't think he's an appropriate defendant in this case on the action, since it would be Ms. Wiesenberg to whom the loan was made and the loan would come back. Doesn't mean, Spencer, you can't help your mom in this
No.
regard.
I understand completely what's happened right now. Thank you, sir.
Okay. So the judgment is against Ms. Wiesenberg for the inability to return the scooter as part of this, and we'll give you a copy of that judgment. And do we send it or do they get it to the file?
Not through the file.
Okay, and then Mr. Wiesenberg, a copy of the judgment will be available in the file for you at district court, so you can always access it that way.
Appreciate it.
All right.
Thank you, sir.
Thank you, folks, and we'll
Thank
get
you.
you a copy.
Yes.
Yes.
I knew the whole time that's what's going to happen.